Good evening. Let's call this meeting to order at 7 o'clock and ask the deputy clerk to read the statement of compliance for the Open Public Meetings Act for the record, please.
The meeting is being held in compliance with the Open Public Meetings Act, with the meeting schedule advertised in the January 10th, 2025 edition of the Trenton Times, and provided to the Trenton Times, the Hunterdon County Democrat, the Buckstown Herald, and the New Hope Press. The meeting agenda was posted on the bulletin board at City Hall and the city's website. A meeting notice was sent to members on the listserv, department heads, and the city engineer on Monday, February 3rd, 2025. Meeting agenda offers planned action items known at the time of publication and is subject to change. This meeting is being recorded and streamed live using the Zoom meeting. Council President Lambert. Here. Mayor Noah.
Here. Good evening. If you would please rise for the pledge of allegiance and remain standing for the moment of silence. Thank you. Thank you, everyone. Nice to see you all. We're going to begin this evening with the bills list. We've had a chance to look at the bills list. It's a short one, but we've got some vendors who, small vendors, and they could, they'd rather have the money now than in 2 weeks. So, I have a motion to approve the bills, please. Okay, all in favor, please say aye.
Aye.
Aye. Abstain. Good. We're going to do things a little differently tonight, and I'm going to start off by allowing, we're going to shift around the agenda a little bit. So I'm going to ask you to just bear with me for a few minutes. The first thing we're going to do is for those people who have arrived to talk about cannabis retail hours, I'm going to allow those people to discuss, to come to the podium and have public comment just for them at the moment. And then following that, what we're going to do is we're going to talk about affordable housing. We're going to have a nice conversation. Answer people's questions and to deal with this very important matter. But since Jesse and Corey and other people have come to this, I think that it's fair that at a minimum that we give them the opportunity to speak to it, though the council will not be discussing it this evening. So if you'd like to step up, begin.
Mayor, just a point of order is that, I think for the cannabis hours and cannabis matters in general, I'm going to recuse myself, because of just not familiar,
Thank you.
folks that are, associated with other cannabis places.
I appreciate that. Is there any concern with the councilman staying at the dais? No, I didn't think so. Right.
Here tonight, I wanted to follow up on my public comment last week to again request an ordinance change to extend the hours of cannabis retail businesses in the central business district to 9 p.m. Be considered at the city council meeting later this month. I've spoken at city council meetings over the last few months about this request, brought in a signed petition in support from over a dozen businesses in the central business district, and at the prior city council meetings received words of support from members of the city council and residents in attendance. After all this progress, I was told to expect our extension changes to be up for consideration on the city council agenda in February, and started preparing my employees, many of whom are here today. So as I mentioned last week, I was surprised when I received an email stating that the majority of city council members had taken a different stance in favor of waiting for former Mayor Dave Delvecchio's dispensary, Jersey Girls, to open and get settled before making a stance to the making a change to the ordinance that is currently limiting my open and operational small business. Based on the response from my public comment last week, there seems to possibly be some miscommunication over the decision to not include this proposed change in the city council agenda for February. So I wanted to come today in good faith and once again request that the city council change the local ordinance to allow for an extension of hours for cannabis businesses in the central business district to 9 p.m. At the last meeting, there was a discussion around proceeding with caution due to the potential future traffic impact that could be caused by Jersey Girls. I spoke with my lawyer regarding this issue, and he advised me that the city council could readily put language in the ordinance change that would allow the option for the city council to require additional traffic studies if needed to permit extended hours, or to allow the extension of hours after a business has been open for a year, and the flow of traffic and community impact of that business better understood. There are ways you can change this ordinance that would respond to the needs of my currently open business, allowing for a pathway to determine if Jersey Girls could be permitted My business did our due diligence to move forward in a timely manner after getting our local and state approvals to open, and we are open and operational now. It's unreasonable to ask us to wait an undisclosed amount of time for a business that doesn't yet have a planned opening date. Baked by the River is ready to demonstrate the extension of cannabis retail hours in the central business district could benefit the local economy, have a positive community impact, and a positive impact on the surrounding small businesses in the central business district. I've already demonstrated this change is widely supported by the local small business community. Baked by the River has been well received in Naperville. We've been open for over a year and have had no complaints. My dispensary has gone above and beyond to try and have a positive impact and be a good neighbor here in town. We're just asking to be open 2 hours later. A request that's widely supported. Please put this ordinance change up for consideration at the upcoming city council meeting later this month. Thank you.
So this is only about cannabis at the moment.
Yeah.
3 minutes.
Sean Ellis, 21 Belvedere Avenue. I am shocked that there's such resistance to Baked by the River being open later. I see it as a win for the city because that means extra cannabis, taxes and revenue for the city. Jersey Girls we've been hearing that they're going to open for years now, but hasn't happened yet. I don't know why there's the delay in favor of them to wait and see. I think the accommodations that Jesse's lawyer put forth are reasonable. And I'd love to hear any arguments against them if there are any. I just want to extend my support to them. They've been doing everything right. Community, particularly on Church Street where they're located. So I don't think it makes any sense to restrict them any further. Thank you.
Hi, my name is Ron Robbins. I live at 52 Wilson Street. I also own and operate a business at 37 North Union. Pardon me, directly around the corner from Baked by the River. I invite any business to stay open later. We are often open until 8, 9 o'clock sometimes in the busier season, and I don't understand why another business in the business district can also operate under the same conditions that my business does. That's all I have to say. Thank you.
I'm Remy Leventhal, 35 Church Street. I'm here to voice my support for the extension of Baked by the River's hours to match the liquor stores in town at 9 o'clock. Not only would this change encourage people to shop at our neighboring businesses that are already later and to add to the town's revenue, but research shows access to a dispensary also reduces overdose rates, which is an active and growing concern in our community and a new hope right now. Additionally, Baked by the River hands out free overdose rescue kits with Narcan and fentanyl testing kits, further reducing the risk of overdoses in our area more than the typical dispensary. In these times of increasing uncertainty, cannabis in that time frame an objectively safer substance. Please take all these points into consideration when it comes time to vote, and please stop pushing back the discussion on something as positive as this. Thank you.
I'm Dominique Dodge. I live at 35 and a half Rear Church Street. I am a resident of Church Street and I'm also an employee at Baked by the River. I would like to emphasize what my coworker said and also I have experienced customers rushing to get there at 7. Like so far this year, a handful of customers have been like kind of rushing to get to the door. They're residents of Lambertville. They work elsewhere, and it's like, there's a little bit of a gap. If you're getting off at 6 and you're an hour commute home, can't get to, so they'll call and be like, oh, can you? And it's like, you have to be here before 7. Thank you.
George Schlobom, 8 Church Street, Lambertville, New Jersey. I would like to state that I'm in favor of cannabis retail businesses in the central business district being able to open until 9 p.m. It benefits the town, it benefits the local residents, and it benefits the local small businesses. It's unreasonable to treat cannabis businesses differently than the surrounding businesses in the central business district. There is a lovely bar across the street from our dispensary that is regularly open until 11 p.m. The ice cream shops are open until 10 p.m. The restaurants are open until 9 to 10 p.m. The liquor stores open until 9 p.m. It doesn't make sense for our business to close hours earlier than all the businesses around us. It doesn't make sense for us to have to close earlier than the liquor stores. My wife has been attending city council meetings for months to discuss this simple change. She's dedicated time and effort to get a local petition in support of this change, and has repeatedly come out herself to represent our business and a simple request to stay open 2 hours later. When I tell that to other business owners in town, they're appalled that this is the process we have to go through just to be able to stay open until 9. It shouldn't have to be this hard. There are other things we could and should be focusing on right now. So please put an ordinance change that would allow cannabis retail businesses in the central business district to stay open until 9 p.m. on the next city council agenda, so that we can move forward and focus on other matters here in our community, like affordable housing. I'd also like to say that I'd like to see affordable housing issues worked on here in the community in more dynamic ways with community support in order to avoid hostilities around issues we need to be working together on. Coming together with trust and transparency on these issues is essential, especially in these unprecedented times where drastic federal changes are causing members of our community to live in fear, members that we love. Thank you very much for your time.
Was there anybody else who wanted to speak to cannabis? Thank you for coming. Sorry about the late notice on the agenda change, but if you stay, you'll hear my reasoning for it. All right. What I'd like to do tonight is I would like to take a few minutes to take us back through the last couple of years, so that everybody in the community can understand kind of where. Yes. Yes, I'm sorry, let's, yeah, may we motion? I would also note, I'm sorry, I forgot to welcome Kelly. We have Kelly Grant here this evening. She helps us on affordable housing, legal issues, as well as Bill Opal, who's the city attorney. So what I'd like to do this evening is just kind of walk you through the point to where we are now. We'll stop at several opportunities. I will ask people if they have a question. If you have a question, you just stand up. Okay, I would like the first. Completely understanding where we are and how we've gotten here. So, so we're going to do things a little differently. So I'll explain some things. I'll say, are there any questions? If you have a question, please raise your hand. Just stand up. You'll ask your question. I will answer it. Perhaps one of the council people might answer it. Certainly Kelly and Bill are here to answer any legal questions that may arise from this discussion. Once all the questions have been asked, if people would like to make a comment, we will have a separate comment period. But I really feel strongly that this first section of the meeting as it's so often pointed out, this is what we do. This is why we're here. Before we begin, I am going to read three things which are on the public record, because I think that they're very important in framing this discussion tonight and in being completely transparent and open with the community. The first is a flyer that's been around. I don't know how many people have read it, how many people have seen it. But it is, it's- yeah, this might be a good time for everybody to check their phones, make sure all their phones are on the dais and that we're all really fully engaged in this. What's that? K Hovnanian development is back. The mayor plans to run out the clock and force the city to build 200 units on the hill, ignoring objections from the council, planning board, and public. The mayor told the Affordable Housing Committee they could not look for alternative sites for the housing plan at the Lambertville High School site, opening us up to a lawsuit unless we identify other sites quickly. The mayor is playing games with the Lambertville High School site. He announced that he is looking to seek a vacant land adjustment for round 4 of our affordable housing obligation and not replace K Hovnanian's site for round 3. KHOV can then petition the court with builder's remedy to fulfill our obligation using the original 200 unit project on the hill, bypassing a vote by the city council. The mayor will not offer straight answers on this matter. We need to watch what he does, not what he says. He did not follow the direction of the council or what the public wanted. He should be following the letter the council got him to send to KHOV to not extend the project. This is a bad project at a terrible location with a landfill that was never properly closed. High levels of PFAS, known as forever chemicals, were discovered in the surrounding neighborhood's drinking water. There's a cluster of cancer in this neighborhood which still has no access to potable water. New Jersey law, NJ Administrative Code 7:854, prevents groundwater recharge in areas where contamination is present, meaning all stormwater from the site must be directed downtown. There are steep slopes and an inadequate stormwater plan, and they will clear cut 12 acres of trees. This is a recipe for stormwater and flooding disaster. Alternative sites that the public has identified, such as the village apartments, which have been abandoned for years and is a public nuisance. Let's make our voices heard. Together we can protect the environment, our community, and meet our affordable housing goals. Second document, which is a matter of public record now, is a letter from Sean Ellis dated relentless national headlines designed to overwhelm us into inaction. I would not send this message if it weren't necessary. I need to share what's happening in Lambertville with you. At last week's kickoff meeting for the Affordable Housing Committee, Mayor Noack once again breached the public trust. He announced that the committee will not be exploring alternative sites for meeting our round 3 obligation, affordable housing obligations. This is a direct betrayal of the committee. Alternatives that do not involve a 200 unit development at the former Lambertville High School site on Comma Hill. Committee members were left confused and blindsided by Noack's sabotage, as well as his stated intent to keep the Lambertville High School site in the plan. The mayor's actions contradict the position of other city council members. At yesterday's city council meeting, council members Kaminsky and Lambert lied at the affordable housing movement to reaffirmed their belief that alternative sites must be investigated, especially since Noack himself abandoned the 2024 Lambertville High School redevelopment plan due to environmental contamination and residents' concerns. Yet when a resident asked if the Lambertville High School site was still in play, the city attorney confirmed that the developer KHOV is still in conversations with Merrick Wilson Divided Property. Despite KHOV losing a provisional developer, the site remains under consideration. When asked if the location was negotiable, council members made it clear. Consideration and his ban on exploring alternative locations puts Lambertville in an should be retracted. KHOP can still build 139 units at the Lambertville High School site, including 28 affordable units. NOAC is pushing for a vacant land adjustment to reduce our fourth round obligation to 7 units, leaving 5 additional units unfulfilled from the ill-conceived police station plan. That brings our final obligation to 40 units. It appears that NOAC is deliberately setting us up for a builder's remedy lawsuit, which, if successful, would allow KHOP to build 200 units, 40 affordable after all. When I asked for public access to the minutes from NOAC's 2 years of discussions with KHOP, both he and the city attorney refused, claiming KHOP now has standing to sue the city. This is a dangerous position, one that the mayor has intentionally put us in because he can then deliver 200 units to KHOP without the council vote that he will never get. Here's what you can do to fight back. Email city council and affordable housing committee members to reject the mayor's intent to keep the Lambertville High School in our affordable fulfill our third round obligation. We must come up with a solid plan to meet our obligations that KHOP Naming cannot challenge in court. This letter then includes all of the email addresses for the city council members and myself, as well as members of the Affordable Housing Advisory Committee. I'm not going to read all of those. Share this email and your thoughts with your neighbors and other Lambertville residents. We have a large contingent of Lambertville's population on this mailing list, but we need to raise more awareness among residents. He is thwarting the will of the people, the council, the planning board, and continuing to push KHOP's goals. We need all eyes on NOAC. Here I am. The next council meeting is February 6th. Here's the city calendar. I know it's exhausting to keep fighting, but that is exactly what NOAC and KHOP Naming are counting on. Their strategy is to wear us down and hope we stop paying attention. Right now, action may feel like a heavy lift amid the chaos of national politics, but it feels better to fight. Council President, you put your phone on the dais. I don't want people texting during this meeting. Right now, action may feel like a heavy lift amid the chaos of national politics, but it
Can
feels.
I ask you to speak up?
Sure. But it feels better to fight back. It feels better to push back against the disregard for climate change, the injustice toward Connaught Hill residents, the continual betrayal of public trust, and the relentless drive to put profits over people's well-being. It feels better to stand together and say, we will not take this anymore. NOAC has lied to us repeatedly. He has suppressed information about environmental contamination and a public health crisis. He must resign. If he refuses, we must take steps toward a recall and limit his ability to do further damage to our community. All I want is to live in a town where elected officials listen to their constituents, collaborate in good faith, and tell the truth. That is not too much to ask. In solidarity, Sean Ellis. Third document is fairly brief, and it came to me yesterday evening. To Mayor Noack from Sean Ellis. In case you haven't seen it, I want to bring a flyer that has been circulating around town to your attention. Please see attached photo. Actually, you didn't say please, see attached photo. You have a lot of explaining to do to the public. Inviting residents to your office hours for private conversations is not for Lambertville. You need to address the assertions in that flyer directly and publicly. I hope you will be able to answer the following questions openly and honestly on the public record. So there are 8 questions here, and I will answer them, but I wanted to go through some of the history first. Every question that people want answered tonight will get answered. All right, so I'm going to just ask that people remain respectful, and that we're calm, that there's no clapping. This is a very serious matter. These very serious documents that I'm sharing with you. People are demanding my resignation, and I want to make it clear that what the situation is. We want to answer your questions, and then I would like at the end of public comment to offer a few personal reflections of the mayor. I'm gonna begin by asking Mr. Opel if he would just take a minute to explain the structure that allows a governing body to consider redevelopment such as we have over the last couple of years.
So I believe back in 2015 or 2016, this Lambertville High School site was initially considered as an area in need of redevelopment under the redevelopment law. Actually, excuse me, 2018. So in June, the hearing on the study that's required under the law, it found that the Lambertville High School site satisfied the criteria that's set forth in the law to designate the property as an area in need of redevelopment. So that's the first step in the process. All of the lots up on that encompassed what's now built.
Speak up a little bit, so I don't know that everybody can hear you.
We just have some people in the lobby.
But if they're in the lobby, they should come in. There's no,
Speakers out there.
okay, well, if you can't hear, please come in. We want to make sure everybody can hear. Thank you.
So that was in June of 2018. After that, the next step in the process is to adopt a redevelopment plan, which sets forth the guidelines for anyone to develop that site, and it sets forth the zoning regulations that they have to abide by in order to start constructing and implementing development.
No, I'm sorry, we're not gonna ask questions just yet. We'll have a moment to ask questions as soon as you finish explaining, okay?
So we have the,
I think people are confused about the sequence here because you asked for questions, people were kind of quiet, and then you turned it over to Mr. Opel. So I think we should give the public the benefit of misunderstanding.
Okay, so
Okay.
let me just.
Thank you.
I'll just clarify. No, Opel is done explaining what gives the city council the right to consider these matters in closed session. If there are questions about that, we'll do this piecemeal so that people have a chance to ask their questions and don't have to ask them 20 minutes later when we move on to a different topic, okay?
so planning board had the hearing in May of 2018, the council in June of 2018 did what they have to do, and they adopted a resolution that designated the area as in need of redevelopment. The next step is the redevelopment plan, which was adopted later in 2018. That sets the development regulations and the zoning regulations for anything that can happen. This redevelopment plan was subsequently amended in 2020. What came up last summer was a further amendment to the redevelopment plan to accommodate what was a proposal to the council by a private developer, K. Hovnanian, who was under contract with a private property owner, which is one owner for the entire site. So that was an agreement that K. Hovnanian and the property owner reached, I would say, it's been going on 2 years, so probably sometime in 2023. They reached that agreement for K. Hovnanian to acquire the land, then K. Hovnanian reached out to the city to see if the city would consider an amendment to the existing redevelopment plan to accommodate a proposed project. The city and K. Hovnanian went back and forth over the course of those 2 years. I believe it was last May where there was some level of comfort to the extent that the council was willing to consider an ordinance to adopt amendments to the redevelopment plan to accommodate the proposed project.
And how the council is allowed to proceed with closed session meetings according to the redevelopment law.
So during the course of those 2 years, it's essentially a contract negotiation. After the redevelopment plan is in place, the idea under the redevelopment law is to negotiate with a developer and come to an agreement that benefits both parties. Exactly, we have these meetings, they're noticed, you're all here, we discuss things in public, there's certain things, and there's 7 or 8 exceptions to the Open Public Meetings Act where the council can meet in closed session to discuss, among other things, contract matters. The idea behind that is that you don't want negotiations between the city and someone else to be done in public. You want those negotiations being private so that different ideas can be explored. People are comfortable to, you know, express opinions, express proposals that may ultimately not make it into the agreement. But the idea is an open discussion, and then after everything is completed, at that point, public vote. So that's why over the course of the last 2.5 years or so, there's been a number of closed sessions to discuss this, because you know, the spirit of the law and the intent of the law contemplates these negotiations happening outside of the public view, and then when the negotiations are complete, the document being brought to the public so the public can have input on what went on in those negotiations and what would ultimately be the final document. With regard to another statute, I know the Oprah issue was raised. There have been a number of requests for documents related to this, and there's certain documents that are available. Any legislation adopted by the council is available, any agreements that are approved are available. The draft agreement that was negotiated never got to the point where it was put to paper in a final form, so that's why they're considered. So that's why there's no agreement that could have been shared. I believe there are some emails that are related to this, but again, not every meeting was conducted in person. Sometimes there's an exchange that happens of either draft terms or something to that effect that happens through email. And for the same reason that the verbal negotiations aren't done in public, those emails are protected under the Open Public Records Act. So it's not, the intent of both of those is not to hide anything. Everything that's available to be shared is on the city website and can be and has been shared. The presentations that took place last summer, those were all available. Some of the specific items that were proposed for the amended redevelopment plan when that ordinance was introduced. Incorporated into the redevelopment plan, so those were able to be shared. But the intent of both of those issues to have some things outside of the public, it's a public policy decision, there's state statutes, and there's a reasoning behind it. It's not to hide things from the public, it's to make sure that when an agreement is reached, that it's the final agreement. There's no misconceptions that, some term was discussed during negotiations, and some people may think that made the final agreement. The idea is to get the final form of either the redevelopment plan or the redevelopment agreement in front of the public, so you can see exactly what the council will be voting on. So those are the reasons for why a lot of these negotiations happen either in closed session or in individual meetings that were outside of public view. When the council has to act, and when there's something to act on, that's all available, that's all done in public. Any agreement that would have been or could have been reached with K-Canadian would have had to have been approved by this council, would have been available to the public. You all would have had an opportunity to review the agreement, express your thoughts. And then certainly you did with respect to the proposed amendments to the ordinance. You had a chance to review those, and for that reason, the council decided not to proceed with those amendments, just because there wasn't support in the community for what they expressed. So I think that's the basics for why we have closed session and why certain documents still aren't available.
I do have a question for you, Bill. Very clearly, the public wants, I'm gonna say the word closure on this project. And we, the city, the governing body, and our professionals are in the midst of a process. With your best lawyer tap dancing skills, can you give us what might need to take place in order to do some of the things that are being asked? I said might. And if you can't answer that question, I'm sorry I asked it, but,
I'll answer it on-
but I think that's. the
I'll
gap.
answer it on one specific issue, so it's something that came up the last time the council met. And it's something that I mentioned a little bit earlier, there is a contract between, as far as we know. There's a contract between Cahill Dominion and Merrick Wilson, or Academy Hill Inc. I'm not sure. Who it is, but which entity it is, but there is a valid contract between the two of them as far as we know, but we have no indication that that agreement is no longer in place. The city legally cannot do anything to break that contract. I would never advise the city to interfere in a private contract between two private entities. It exposes the city to significant damages and liability, so that contract is in place, and it's for that reason that. You know, in good faith, I can't advise the council that they're not gonna continue to come back to the city and try to negotiate. So that's out there, that's a fact, and, you know, this whole project wasn't the city's brainchild. This was two private parties entered into agreement, and they came to the city to see if this. The redevelopment law is, it's a public-private partnership, it's, the intent is to benefit both parties, and part of what. Those negotiations, they thought would benefit the city was its affordable housing obligation, so. That's why the city considered it, it wasn't something that the city reached out to Merrick Wilson, we didn't. That's where it all started, and it was something that the city in good faith entertained.
Thank you. So I think it's maybe fair to rephrase what you're saying. And stop me if I'm incorrect, is that much of this is being conducted. We can't control what other people do, right? I mean. You know, we can give them, we can vote on things and we can state our acceptance or refusal of certain proposals. But people are going to do what people are going to do.
Absolutely, and
Is
they
that
did,
fair?
they did that before, I mean, I don't think the city was aware of their negotiations, I certainly wasn't. Purpose of the redevelopment law is, as I said, obviously, there's going to be a private developer involved 9 times out of 10, and they're going to, you know, look to build a project that they can benefit from, and you do that under the redevelopment law because the law gives the city tools to kind of control to some extent what gets built. We can't control who buys the property, we can't control who owns the property. Unless the city owns it, but in this case, it doesn't. We can't control any of that, but we can control what gets built under the law, and that's why it's a beneficial tool for the city.
Thanks. I'm just gonna say one thing. When we talk about the timeline, when I talk about the timeline here in a few minutes, we'll be able to kind of elaborate on as they relate to the redevelopment law.
I have a question. Had his hand up a while ago.
Yeah, if you wouldn't mind, when you stand up, if you just say your name, please, and speak loudly so that everyone can hear you.
Good evening, my name is Ryan McFadden, I live at 23 Old York Road. I moved here in 2018, late 2018. I want to know whether the ground was tested by the developer and or any other parties in order for that to be reclaimed or redeveloped. Typically, if there's a brownfield or a vacant lot or something to that effect, if there is a contract negotiated, they have to do certain tests for the EPA in the state of New Jersey. So I want to know if that stuff was done. If that was done, were there indications that the ground was affected? And then does that change whether they will be getting city water? Will they be getting any infrastructure support? All these questions come up about how 200 additional units could be placed basically behind my house without massive infrastructure reconfiguration, including city water. So I mean, right now we're dealing with non-potable water. And if these guys decide to tear up the ground, that's going to agitate anything that's in there. Right now, we're getting a slow leach. If they just make a giant hill on our hill, it's going to have a massive effect on everybody. And that needs to be taken into consideration. So my first question is, was the groundwater or dirt tested to make sure that there was even a viable location here? Because if you're talking about building a playground and there's kids that are gonna be running around, kids eat dirt. I have a 1.5-year-old. If the kids eat dirt, are they going to be exposed to something that will have long-term detrimental effects to their health?
Please, Bill?
KME indicated to us that they did their due diligence with regard to environmental studies and residential standards, and that didn't, and as just saying what the concept plan indicates is that they're not going to build housing on what's known as the former landfill that's up there, but for the balance of the site, they did indicate that they can remediate it in accordance with residential standards and the applicable state.
So not the landfill part, but the PFAS part, where like the Teflon factory goes.
The high school site and basically everything other than the landfill site, they indicated that they can remediate it, yes.
Sorry. Just questions, please, yes.
I'm Dr. Mullane, and I live at 245 South Franklin Street. First thing I want to address is that statement you made was false. These PFAs go through the water. I talked to an attorney. (3M) and also DuPont, knowing that these chemicals were what they were, potential carcinogenic, back in the 50s and 60s. So what you said, sir, there is no remediation
Sir,
for any of these chemicals
Sure.
because they'll go down and get into the water.
you have a question?
The question is, have you guys thought about that? And I read on this piece of paper that there's a large cluster of cancer in that area, and that probably came from the Teflon factory. Now, if all of that is true, has this been looked at by EPA, and is it up to EPA standards for PFAS?
Well, I'll respond initially. I'm telling you what's been relayed to us, and this is a company that has spent 2.5 years doing due diligence. It according to what they've represented to the city, they can build on part of that site, and that's what they've said to us. And I'll further note that our redevelopment plan, the existing redevelopment plan, not even the amended one that wasn't adopted, the existing redevelopment plan requires that remediation take place in accordance with NJDP standards. So if they couldn't do that, they can't build.
Okay, I just want to tell you that the EPA standards are the law of the country. We know that the federal law supersedes everything else. What I want to know is, has this been looked at by EPA? And how do you explain the large cluster of cancer? And it's just a coincidence that they had a factory up there that makes Teflon products. We know that all of this comes from that area. Okay, that's the first thing. And the second thing is, how are you guys going to drain this? I mean, how, in case of storms and so forth and so on, that all of that could be coming down into the city and into our sewerage and God knows where else.
So
Excuse me, Bill, maybe I don't understand, but, don't don't developers in the state of New Jersey need to comply with DEP standards, state DEP standards? Is that the jurisdiction?
Yes,
Do developers go directly to EPA and around DEP?
No,
That's, because I think that's a disconnect on a point
it's
of
New Jersey
understanding.
Department of Environmental Protection.
There are.
Their standards, but I mean, they also can't adopt regulations that are, there is the supremacy clause, as the gentleman referenced, and, those regulations are in place and they have to abide by those.
Just one last thing.
Sure.
If these things do go into the water and they do live for hundreds of years before they break down, you guys are setting yourselves up for big lawsuits if you start to develop and more cancer comes to that area. I mean, we've seen this before.
Thank you very much. Thank you. We'll take, wait a minute, I think Councilwoman.
PFAS, I think it would be helpful And we know that because of the high well numbers that have been reported to the DEP, not only in Lambertville, but in West Amwell, that DEP has then said that they were going to open an investigation as to the PFAS contamination, as to where it's coming from. So it's almost like there's a new set of data, and we would also, I would think, a question that I don't know if we don't have an answer to, but a question is what is the status of the department's investigation and in getting back to us, because it seems to be an important piece of this information. Environmental regulation is very complicated as to who's doing what, but we do know that DEP not only would have which will certainly have a lot of impact on our area, on the area here, on the area for homes in Lambertville and for the area.
There's nothing you can do. There's nothing, sir, I just want to finish it, that there's nothing you can do about what you have before. It's all there. With what you're gonna build future,
Excuse me, others will have questions as
okay,
well.
it's not a question, it's a
Yeah.
statement about it,
Thank you
and
very
for
much.
looking into this.
Thank you very much.
Yes.
And we appreciate the
Let me-
effort that you're putting in.
I have a question on Oprah, but I'll answer his question
No,
quickly.
please don't answer his question. We will answer the questions, Mr.
Well,
Taylor.
separate, if the program's privatized, it's up to the consultant for the property owner, not the DEP. So just like you understand, that's where the cleanup comes from. That's the law. My question is to you is, you're talking about this contract that was negotiated in private, that no longer is valid. So the purpose of your closed sessions and the minutes of them are no longer protected because you're not withholding things from the applicant or the previous applicant, you're withholding it from the public. They know what you said to them. They have those documents. They have those emails. The public doesn't. So I'm gonna give you a case on point. Ramsar versus,
May we have a question, please?
yes, I'm giving you a case on point. Have you ever looked at Ramsar versus DEP? Sierra Club was a party of that lawsuit. The state of New Jersey negotiated a contract to lease part of Liberty State Park to a private golf developer. The Oprah was denied. We sued. The appellate division ruled in our favor that those minutes and emails had to be released. And that's a case on point.
I'm sorry, what was the question?
The question is, have you looked at that case?
Okay,
Because that's a
thank
case
you.
on point.
Have you looked at that case?
Off the top of my head, I don't recall.
I'll give it to you.
I had it, I just pulled it up, so I'll take a look at it.
Yeah.
Okay, so how many people do we have online?
Right now we have 32 online and I have somebody who's had their hand up
Okay,
for quite some time.
so, so we'll ask have one more question in the room. This is specifically about the redevelopment, law. Okay, just about the redevelopment law. We have all night long. We can stay and get into the weeds here as much as, not the weeds, but we can get into the details as much as people want. But it's important that we just take things one piece at a time. Go ahead. You can please stand up and ask your question.
Yeah, I just wanted to follow up on something that Mr. Opal said about that investigation that, so I was watching the Affordable Housing Committee's video and the city planner, Elaine Chisholm, I think is her name, said that the city did an investigation that determined the landfill could be developed. Did she misspeak? Was that just us taking the K-Hub's word that it was redevelopable without seeing anything? Because this company has lied and had to settle
That's the
lawsuits across the country for stormwater runoff problems and Clean Water Act
Okay,
violations. So,
we have the question. Thank you.
yeah.
Since I've been here, the city has not done an environmental investigation. So
No due diligence on the part of the city.
since 2020 is all I can speak to.
And there's no investigation there.
So we're gonna go to the people on,
There's two
on.
parts. So the
Go ahead, Bill.
DEP is doing the source investigation, they've confirmed that, but the city has not undertaken as it's set forth in the redevelopment plan, whoever ultimately develops it, whether it's a purchaser from the owner or the owner, they're responsible for the remediation. So the city hasn't done any independent.
So is this a
investigation as
changed
far as that.
circumstance then, because we didn't know about this?
We can talk about that later.
Is it
I wanna
just
get
change
to other-
circumstance?
I wanna
Oh, that's, we're gonna address that.
Okay.
We will address it. We will get to all the questions. So Cindy, now we're gonna go to online. I'll come back to it, I promise.
Okay. Evie, please go ahead and state your name and ask your question or for the governing body. You have to unmute yourself. Evie, did you have a question?
Yes, I want to tell you that we can't hear every word you're saying. It keeps going in and out.
Okay.
Okay, well, we will do our best to speak loudly. This is one of the.
It isn't whether you speak loudly, whatever system you're using shuts you off every few seconds.
I think that's because the other noise in the room, it's a microphone which is pulling away from it, so we'll do the best we can.
And
All right, thank you.
Thank you. A couple more questions and then we're gonna move on. Go ahead. I'm sorry, so you first.
Hi, Stephanie Noy from Wilson Street. I was just wondering, when you started speaking about the whole process, found myself wondering, what is the initial process that the city engages in so as to ascertain what parcels of land are adequate for redevelopment? I mean, we're here today because people believe that parcel of land is not adequate for development because so I guess going back to the very beginning, what did the city do and what will it be doing in the future when it's looking at other parcels of land for redevelopment? What is your process?
It's statutory. It's all laid out in the redevelopment law.
But how are you assessing?
Yeah,
What's to benefit the people of this town based on the topography, the landfill, et cetera?
the old term was blighted. It was properties that were blighted, were candidates for redevelopment. And back in 2018, as I was going through the history of how this property came into being considered for development, the redevelopment law lays out 6 to 8 criteria that has to meet one of the 6 or 8 criteria in order to be designated. And the city planner will visit the site, they'll prepare a report, they'll look at old records, and they'll put together a report that says this property doesn't meet the statutory standard or it does, and it's for these reasons. So back in 2018, at least one of the reasons were applicable to this site. And I can tell you, just physically looking at the site, and without getting into what's in the soil or anything like that, but it's dilapidated, it's underutilized. And I imagine those are some, and the report is definitely a public record. If you want to take a look at that report, I'm sure somebody has it on file somewhere if it's not already on the city website. But that would go through all of the criteria for why it was designated. So that there is a basis for what meets that. And going forward, without getting too much into hypotheticals, if the city looks at any other sites in the city that it thinks might meet these criteria, the same statutory reasons would apply. You'd have
But I
to,
mean, it's incumbent on us to dig a little deeper, right? To ascertain if it's adequate for the usage that you have in mind, right? When you know there's an open landfill, when you know there was a Teflon plant, when you know that it's on a hill that could if it is right for or should be redeveloped
we're not,
in that particular way.
I understand what you're saying. The city isn't developers. We have professional planners, we have attorneys, but the city is not a developer. If it designates the site and the whole purpose of the redevelopment plan.
But it's how we
after it's-
designate it, that's the point.
Yeah, I
How we
understand.
designate
You have
it
to
begin
designate,
with.
yeah, you have to designate it first, but then when you get to the plan, you determine what the uses can be. And what regulations have to be in place. So for this site, there was a lot of. It was considered for residential. There's a lot of built-in regulations in the redevelopment plan that say. you have to comply with the city's stormwater ordinances, or you have to exceed them in certain circumstances. You have to, these are the steep slope issues, you have to account for that, you know. There's a lot that goes into the plan as far as development regulations that are specific to the site. And you only get there if you if you designated that site.
So to be
as-
designated to take on 200 plus units, given,
No, it's currently designated as an area in need of redevelopment with 139 units on
Okay.
it. So
so I guess that is the perpetual, that's the ongoing question here. How did it ever get
well.
designated
I'm-
to possibly hold 139 and more?
That's 2 cars per.
And 2 cars per, I mean, you've heard it, we've all been to these meetings.
It goes to different, and then and the regulations that are in there require, and if you can't do it, if a developer or real estate developer cannot meet the standards in the redevelopment plan, they can't build. So the city put these regulations in place and said the only way you're gonna get to build is if you check all of these boxes, you satisfy all of these
Wait, but
regulations.
how could they check the flooding box?
Okay, you know what, I'm sorry.
That's up to them to.
We're gonna move on. Is there somebody else online?
There is, Mayor, but wasn't this part of
Is there anybody else
There
online
is.
with a question?
Karen, please go ahead and unmute yourself and ask your question. Karen Atwood, please go ahead and unmute yourself and ask your question.
Go ahead.
Jennifer Towns, 14 Hancock Street. I just have a question for my understanding.
Could you stand up so others can hear you, please?
Sure, yeah.
Thank you.
Jennifer Towns, 14 Hancock. Just curious about, for my understanding, when you went back to the beginning, when you said the 2 parties formed a contract with each other, that, you know, whoever owns the property, he talks to a developer, they contract with somebody on my property, does that mean Lambertville has to like do whatever I want to do?
No.
So did you change your zoning to meet, so we could build housing on there? Is that what happened?
No, I mean, you don't live, as far as I know, in a redevelopment area that's been designated, so the city. you
No,
can
that's,
sell
I'm
your
just trying to
property.
understand. I
Yeah.
don't understand how that
No,
happens,
The
so.
city's not involved in, like, if you want to sell your house, like, the city wouldn't be involved.
No, but if I
This-
sell it to, you know, a developer and I want to put, you know, a small apartment complex, that's fine.
It depends what the size is and where you live and whether the zoning allows for that. That's potentially a planning or zoning board issue,
Mm-hmm.
but it's not really a real.
Okay, so it was designated a redevelopment issue, whatever, before. That's why I need to know. Thanks.
John, and then we're gonna move on. Go ahead.
John Towns, 14 Hancock. I guess the bigger question that everybody's having is, how was it that the high school site is point them out? Because that's not making it to us.
Thank you. The high school site is the only site at the moment that is an area, that is a designated redevelopment area. And we do have the village apartments, which has been declared an area. Development plan and put it in on that property. So we have a redevelopment, so the village apartments have been declared an area in need of redevelopment. The high school site has a redevelopment plan, so it's already gone through all of those steps. And is there another
Police
one?
station.
The police station, thank you very much. The police, I forgot about the police station. The police station is also an area in need of redevelopment, that has been declared. I think that will hopefully answer the question. Judy, we'll make you the last question. If you could stand up, please.
Judy Gleason, I just wondered 2 quick things. One, the December 6th letter from the mayor said we had decided to step away from the site, from the high school site and the Hovnanian deal. We were stepping away, we weren't doing it. So part of the reason some people are here is, why are we talking about this? We said we weren't doing it in December, and we all saw that letter, but the second thing is, from seeing the closed but then opened minutes from the June, I think, 6th city council meeting, there was a plan presented to the council from a developer who wanted to do something with the apartments. That you just said we didn't have a plan for. We do have a plan for. They gave you a plan for that. So I'm just wondering, I'm just struggling to stay with what we came here for. Did we back away from the Hovnanian people? And did they and do we have a plan to look at other places? Because as we have said many times, for one of the times I've located in July, 6 months ago, said, why are we not doing other things? We keep talking about we have to look at other sites. Why are we not looking at other sites?
Thank you.
You're welcome.
We're here tonight because, I think that there's a misunderstanding, and I'm gonna do my best to clear that up. So I'm just about to speak a little bit to the timeline, and I will get to the question of December 6th and everything else. So if you give me a little latitude, it's coming. With respect to the village apartments, even though we're not talking about that tonight, because it had been declared an area in need of redevelopment, the city council did have conversations with the contract purchaser. Those conversations ended the moment the contract purchaser, to my surprise, and the surprise of everybody on the council, came to a closed session meeting and declared board. So they said they were going to proceed directly to the planning board. We released those minutes, those plans, and we have not heard back from them. And it's no longer up to the city council to engage with them because they said they were going to go before the planning board. It's inappropriate for me to have a conversation. We're going to move on to just, I'm going to go through a little bit just to remind everybody of the just going back to how we got here. So Mr. Opel mentioned that Kay Hovnanian came to the city Opel noted had been working with the owner, and they proposed a plan. So the city began to have conversations and negotiations. The short time, the most direct route here is, and then if we have questions after, we can do that. So in April of 2022, I'm sorry, August of 2022. So this is just 5 or 6 months after they initially came to the city. There was enough information and enough forward movement that the city council and I designated Kay Hovnanian the conditional redeveloper. And basically what that does is that allows us to set up an escrow account so that when our planner gets involved, when our engineer gets involved, when Mr. Opel is involved, that Kay Hovnanian pays for everything. So, it's just, the point is, shouldn't be lost on anybody that to date, the city has not really expended anything. There may be some minor costs, but all of the burden of presenting their plan to us and review from our professionals was all paid for through Kay Hovnanian. So in August of 2022, the city declared them conditional redeveloper. It was a unanimous vote. And in that resolution of August 18th, 2022, it also noted that Kay Hovnanian was proposed in public, on public record since August of 2022. I will note that the process slowed down. We were having conversations. The process slowed down in late 2022 because of the elections. So we had 2 new council people who were elected in November. It took us a while, after they were to deal with any questions or concerns that they had. And then we continued, the city, council continued to have conversations with Kay Hovnanian, in good faith. And I will note that by the time so between the time we designated them the conditional redeveloper and the day that the ordinance was introduced in 2024, we had extended that designation 5 times. The city council had done that. And if we weren't, if we had come to an impasse, we would have said no, right? So that's an important thing to keep in mind. This is really a long process, and I understand that there's some unease about the process. The ordinance of the redevelopment plan was introduced in May of 2024 unanimously, I would add, which is also another indication that everybody on the city council felt that there was enough forward movement with this plan to continue forward. The city held a special meeting on May 30th to address residents' concerns and questions. And then subsequently in the summer, the ordinance was tabled, as everybody knows. In the summer, the city continued to meet with Kay Hovnanian through the summer into the fall. Negotiations continued. But they continued in good faith until we reached a moment where the city council decided that we were not going to continue moving forward. So on December 6th, I sent a letter to Kay Hovnanian and informing them that we were not going to renew their status as the conditional redeveloper. I also sent a copy of that letter to Judge Miller and the court adjudicator Banish. So for those of you who have not heard me talk about this before, kind of concurrent with these conversations with KHO, I was meeting with the court and Fair Share Housing and the court adjudicator probably about every 6 to 8 weeks over the course of the 2 years, 2.5 years. The court was very interested in us moving forward with some kind of plan, given that we hadn't met all of our third round requirements, given that the station 5 units did not move forward. And we all talked about this, and at the time it was felt that this was going to be enough for us to show continued good faith. The letter went out on December 6th. A couple of things that probably the public doesn't know, and I'll just highlight these. Following that letter, Kay Hovnanian requested a meeting with the city. Council President and I, with Bill and a couple of other professionals who was at the meeting, Bill was you and Council President. At their request, we met with them and we listened, and we didn't say anything. We just listened. Following that meeting, the council briefly discussed in closed session the meat of that meeting, and then on January 28th, we finished that discussion. The city's position has not changed. So I want to be clear about that. The city's position has not changed since we sent the letter on December 6th. So what we have here, and I will take questions and I will answer them, is a failure to miscommunicate, as Lieutenant Brown says. There has been some misunderstanding. Perhaps people haven't expressed themselves very clearly, but the city's position as of now, as of December 6th, has not changed. We have let the conditional redeveloper status expire, and that's where the city is. That's where the city is. I think some of the confusion may come from the Affordable Housing Advisory Committee meeting. That was the first one that we had. And during that meeting, early in that meeting, I said I did not want to speak about the third round housing obligation. And perhaps I could have said it a little bit better. What I was trying to project was that we have a group of volunteers here. We have a lot of work. And I was concerned that if we started to talk about this, having this conversation, that it was going to be difficult for our volunteers to do the work, and it was going to been there's never been a moment when I have said publicly, I stopped talking about K Hovnanian in the summertime. I stopped talking about it publicly. I'm very confident that nobody in this room can find any record of public comments that I made. I know when it's time to stop talking, and I did not talk. Our conversations were held in closed session, and I thought it was wise not to talk for a while. And I have not spoken publicly about this. If anybody can find anything to the contrary, that would astonish me, because I don't believe it exists. So I want to be clear about that when we get back to conversation a little bit later on about, I'm a liar. The point is that I may have said something ineloquently, but there was at no time would I have ever said that the city was not going to meet its obligation. The high school site is a mechanism, so it's a means to fulfill the obligation. For everybody, but that's where we are. So I just want to talk a couple more things, Jen, before I take questions.
And I'll be next.
You'll be next.
Okay.
You'll be next. Jen's next. I think it's important to know just a couple of things about the summer as well, right? So after this was tabled, or during this was tabled in July, we had a resident contact us to let us know that there was a positive PFAS result. And then we started to see more, and we asked residents if they were willing to share that information. We took that information, Cindy's forwarded it to the county and to the state. We know what else the state has been involved. We held a special meeting to inform people and answer questions about the spill fund and what the DEP has promised to do. That's all I can say about PFAS at the moment, and we're not going to be able to talk about PFAS tonight for some reasons that may be clear to some people. And if not, I'll ask Mr. Hopel to do his best to not talk about it and talk about it. I think that's pretty much, those are the main points that I just wanted to talk about in terms of the process from the start to where we are today. Yeah.
So, also I think I want to say is where it was confusing was back in December, whenever you sent the letter to say we're not following through with the reconditional developer or whatever they're called. I know I did. People took it, and then to hear you be like, oh, we're still building houses up there, it's like, he's a liar. He just said to all of us that it's canceled and it's not happening because maybe it wasn't clear enough for people, down at my level that need to understand it that way.
Yeah. Go ahead.
That's just, honestly, that's how I took it when I heard
You
that.
have a question?
Okay, this is supposed to be a conversation between the council and the community.
But we're trying to get to facts here. We're not trying.
I'm trying to give you facts. That was my
She's trying to get
understanding.
you to, which is a disconnect, which is. They thought that all that development was not gonna happen.
Thank you. Yes.
And I understand your point. and
Yeah.
I think a lot of people. thought
And
the same.
that's why, and please, we're the residents of this community. I'm not sitting here. My opinion or comment may not be a specific question, but it needs to be heard by the council, and I don't need snarkiness from the dais when I speak. I think that's rude. Thank you.
Other questions?
Yeah, could,
We're gonna go to somebody.
no, can I just follow? I just would like to.
It's a designation, as I said a little earlier, it's a designation that the council would vote on. So the council voted that K Hovnanian was a conditional redeveloper. And basically that is a tool that allows us to process escrow funds. So it's not the bill, can you just?
The only reason I did that was so KHOV would pay for all this stuff as we're looking into it, so.
So rescinding.
That we're dealing with that, we're paying for that city of Lancaster. We can't pass that on to the conditional development.
Well, there are no additional costs, right? So it's a. Our professionals to charge, X amount of research or whatever it is to an escrow account. So basically, it has
negotiations with any developer, it's their project. So the city shouldn't have to pay for it. So when you have the conditional developer, they agree with that, they put $15,000 or $25,000 into an account, and my time, the planner's time, anybody's time that is used towards, furthering negotiations on that project, it's drawn down from that, and the city doesn't have to come out of pocket for that, so it's not passed on. We'll consider it, but you kind of have to pay for it, so that's how that works. The conditional designation ended in December. The city was no longer negotiating with K Hovnanian, so at that point, and the designation, I think we kept extending it for either 90 or 120 days at a time. It was expiring, I believe, the week after.
It expired, I think, 2 days before 2 days after I sent the letter.
And then the council would have had it act at its next meeting, and the council wasn't good, the mayor and council were
So
not
those
going to.
negotiations means what?
And the 200.
So
Good
we were,
deal.
the negotiations that we were engaged in were, right now, the redevelopment plan allows for 139 units, they were asking for 200, and the city was trying to. We got to a point in December, probably before that, where we realized that there's not the support for this project as it's currently conceived, so we let K Hovnanian know that their conditional designation status wasn't being renewed, and that there was really.
22 South Union Street. Okay, you sent the letter out to the developer of December 6th, was it? Something like that. Okay, and that reflected the decisions that we sort of, I thought, mutually came to in our previous meetings, that the project wasn't going to be feasible in its, current form, and it had to be tabled for the time being. And I guess that's what the letters.
Developer status, so it just.
Okay, well, basically, that's what I meant.
Right, okay.
Now, you said you had a meeting where you said nothing and the developers did all the talking.
Pretty much.
Was that a threat of a lawsuit? Because they already had previous agreements and we were gonna take them out of it, so now we owe them $10 million or something?
I can't speak to that.
Well, the
There was,
jury might.
there was no explicit threat of a lawsuit, just knowing what the law is, it's out there. I had to be honest, it's a possibility. It's in a case like this, but they did not explicitly threaten that they were going to sue the city, and
Okay.
the damages that you referenced, they're not applicable.
Right, okay.
Monetary.
Michelle?
Hi, Michelle Glassberg.
Yes,
Sure. Who owns the land now? Is it Hovnanian or is it the original owners of the land?
As far as we know, the original owners still own it. We have not been made aware of the fact that it's changed hands.
Thank you.
Hi, Beth O'Brien, 2 Hancock Street. I think there might be some confusion during the Affordable Committee's recording that I listened to. It appeared that there was still an intent to develop on the hill. And I thought the Affordable Committee was put together to look for alternative locations for the 3rd round. I understand that our obligation in the 3rd round doesn't change, but isn't the location still up for negotiation? And so can we renegotiate other sites? And if that 139 unit development is still in our plans, can another developer walk up and say, hey, I can do that for you? And then we end up doing this all over again.
So all I will say, before I turn this over to Kelly, is that if I was unclear, I apologize. We don't always speak, I don't always speak eloquently. I rarely speak eloquently. And it's quite possible that you know, we never really, I don't know that we ever specifically talked about the Affordable Housing Advisory Committee dealing with third round. It's possible, I'm gonna say it's possible, I don't remember it. And what I meant to say, and what I believe Julia should be right, was that the Affordable Housing Advisory Committee, which I'd like to talk about a little bit at some point, is there to help us identify and advise the city council on our total numbers, right? So we know that our numbers will not change. The mechanisms may change. It's possible, and Ellie, I'm gonna kick it right over her in a second. It's possible that
It's just mechanism.
a mechanism, so the high school redevelopment area, plan is a mechanism. It's a way for us to
A way.
to satisfy our number. So the number stays the same. The city, you know, and have Kelly explain this.
Was entered into in May of 2018. And at that time, the city's obligation was 88 units. In the settlement agreement that was negotiated, there were a variety of mechanisms to fulfill the 88 units, right? So number one in there, is the Lambertville High School redevelopment site. And again, as we all know, it's for 139 total units with the 20% set aside. To the point that this letter in December went out, or the confusion, yes, it's correct that the 200 unit count plan is no longer being discussed, from my understanding. Redevelopment plan that the city did adopt, consistent with the 2018 settlement agreement that allows for 139 units on that site, producing 28 affordable units. That still has to be solved for.
You solved it.
And well, I think what Beth was asking too, though, is if a developer came today and says, I have a contract on this property, I want to build 139 units in the redevelopment plan, can I do this? And I believe.
If the
yes.
plan is consistent with what the redevelopment plan, the developer's plan is consistent with all the outline in the redevelopment plan, the answer is yes, that 139 unit plan is in place.
I'm gonna ask one other question because I think it's important here. If the city gets to a place this site from its plan and find a different mechanism to fulfill the 28 units that are required by the settlement agreement, which is long. What would happen with the property? Let's say the city was successful, the property would revert to prior zoning?
That's correct. So there was, again, my understanding, before my time, I began representing the city till 2019. So this negotiation and the settlement and the redevelopment plan was done prior to me helping out the city. I understand that the record owner has approval for 67 homes on the lot. That's an as of right. So again, if you were to rescind the redevelopment plan of 139 units, he gets what he always had, the zoning that ran with the land, whatever that is. So that you cannot take
with climate change and then flooding studies and statistics and, you know, I mean, the impacts are changing, you know, the world is dynamic, it's not static. So what can we use other criteria? Okay, maybe DEP will get involved, maybe they won't. I don't really know how well that works, but what about the flooding issues? What about the traffic issues? What about all these other things that impact what we approve and what we don't? And how do we protect ourselves? How can you protect us from the negative impacts of any kind of development up there?
Simply, and Bill certainly already supplement, but simply those,
Would you speak
that,
up, please?
that criteria would be included in any redevelopment plan. Standards that the city would be interested in, by stormwater, for slopes, for density, for traffic. All of that is comprised in a redevelopment plan, independent of affordable housing.
And so are we able to give updated information and updated criteria based on the flooding, based on the destruction to certain homes, based on, I mean, there's a lot of new information now. We agreed to it how many years ago, so now it's, I mean, there has to be a way to protect us from perils. I mean, there has to be.
So I think you're talking about any development there, right? Not just the plan. So you're asking, can we prevent all development there because of change of circumstances, climate change and that, correct?
I don't know about all. I don't really know. I just know that that's.
Because those are two different answers.
That
That's why-
scope is insane, and I don't know. I would like to not have any, but I realize that's private property.
So I'm just, you guys, put your
Redevelopment plan that is in place now is designed to account for those issues if things change. Obviously, the redevelopment plan can be amended to it, and that's,
But
and
that's,
I'll also mention that apart from the proposed redevelopment plan that was being considered last summer, that didn't just account, we didn't just cross out 139 and put 200 units. We accounted for an updated stormwater management ordinance that the city adopted. We changed regulations related to steep slopes. We put language in there specifically that they would we discussed, I don't know if we wound up in final, but we did discuss requiring them to obtain a parking traffic circulation report prior to going to the planning board if they got to that point. So certain things were definitely considered beyond just the density for that. So the redevelopment plan is generally what encompasses those changed circumstances, and the city, I think, our professionals did as good a job as we could of bolstering the regulations that were in there to account for. I mean, since 2018, a lot has happened in Emeryville.
that's for sure.
So, you know, we changed the stormwater ordinance, made specific reference to that, and then made other requirements that would have gone along with, you know, the additional density if it was approved.
Okay, we're gonna go to Sandy and then Jeff and then Sean.
Karen, you mentioned Sandy Hanna. Possibly that there's something going on where they're going to explore it or no?
As far as, well, the ordinance said that we're going to be looking into the PFAS and starting an investigation. I don't know, they don't communicate back to me,
There is
but
something
I
on
would
the website.
imagine that they should be
Is there-
communicating back to
That
the
could close
city and
that
we should
property
be happy.
down if they got into that. Is there anybody spearheading that from the?
Well, so the DEP, I can just give you I haven't talked to it. We've had an email from the DEP in the last week or so. The DEP has already conducted some sample testing in wells on Connet Hill. As well as the data that they have presently. So in my first email exchange with, I don't remember the name of the gentleman from DEP did commit to doing a source investigation, but he was also very clear that he was going to put a timeline on it. There's a lot of PFAS, there's a lot of, the state has a lot of issues, and I don't know, I don't know where we land in kind of the priority of that. But they have committed to doing a source investigation, yes.
Into that property.
Correct. Well, no, not. That's not, that would not be correct. They will do a source investigation. Unless, Bill, correct me if I'm wrong, but no one in this room can definitively say where the PFAS is coming from. So I will say that there was recently another example, another house that I heard that was nowhere near anything, way out in the woods, and it's well tested for positive PFAS. So we don't know enough about kind of how the water runs underground and what the source. So I think that, Jeff.
I just think that it is, you know, the information that they're going to be that they're going to collect does lend itself towards, you know, some of the discussion of what's happening here, right? I mean, it only bears the, you know, so it's kind of like just saying, and when it comes to the source, if you give it a grade, it's incomplete, you know, and so that is part of the process, and that's certainly, you know, a problem, is problematic.
It is problematic, and what I don't want to do tonight is get into kind of the what ifs, but at some point, it's likely that some entity is going to be held somehow responsible for this, right? And it's not possible for us to say who that might be or to what extent. Please go ahead and ask your question.
Yeah, this is a question I've asked pretty much at every council meeting the last 4 or 5 months. So will the council remove the hill from the town's affordable housing plan? Petition the judge because of all the problems with the site, from water to contamination. So that's one which I've asked at least a dozen times. Second question is, will you then direct the planner to develop alternative sites for those 28 units from round 3 and whatever we need to do on?
Thanks. I'll take the second question first because it's easier to answer. We will be looking at every available site. So when the Affordable Housing Committee meets on Monday, I meant to give you guys an update. I shouldn't call you guys. I meant to give you an update about the committee's work. Today, Cindy sent out a number of documents and resources. I will be sending out a letter to Councilman Lyde, will be presiding over the meeting. I have a college tour up in New England with my son, so I will not be there. We had a meeting with our planner a couple of weeks ago. We've included that document, the memo from that meeting, which also generated a spreadsheet, which effectively looks at almost every property in the city. And the Affordable Housing Advisory Committee will start to look at those properties and begin to make recommendations and have conversations about those properties. We have to meet the number, and we've got to find where we're going to do it, right? So that's what I can say about that. I'll just speak very generally about the first question. I don't think, and I'll let Mr. Opal and any other council members speak to this. I don't think that we are currently in a position to consider that, given the possible ramifications of the conversation with the court. So that's all I want to say on it. And Bill or Kelly, if you want to if you can flesh that out for me or for us, and if the council members once.
Something the council can unilaterally consider. It's part of the 2018 settlement, and we would need consent from Fair Share Housing Center, and we would need the court's approval in order to reopen that settlement agreement and then try to do that. So it's not just the council can propose the ordinance next meeting and go forward.
In dialogue.
I would just add, Jeff, I think, you know, those are two really good questions. I think we need to do the second one first. We got to come up with a plan. And then when we have a plan, we go to the court, because the court's not going to let us do anything until we have a plan. And, you know, we've been talking about that for a while. We need to have a plan. And so that's the most important thing to do. We got to find another site.
I think the question really is too, in terms of like the confusion, because confusion confuses me, is I think folks want to know, well, what are we going to do next now that we sent this letter in December? Because logically you think, well, gee, then the city, right, goes back to the court and says, oh, this site, and I know there's a focus on the plan of how we'll replace it, but I think we also have the due diligence to talk to the judge about the problems on the site that are there that we uncovered after, you know, with all the discussions that we had in the past year when we first designated as one thing. We've learned certainly a lot. Nobody ever knew that they had all this PFAS in their well. Nobody I never knew that the high school was used for anything other than a spooky building after it closed, but it turns out that, you know, somebody was manufacturing something that maybe there's a problem from it, maybe there's not. But to kind of, that you have that discussion, so then the court recognizes, gives some opines on that or something, and then you move into, okay, this is what we're gonna do for to replace those units, Judge Work, you know, this is good faith, we really wanna do this, you know, something like that. Is that the process, like, how do we deal with the court? Because it is kind of a mystery. Do we have a case management conference, or do we, you know, does the judge call it? It would be interesting, I think, for everyone to understand how the court, you know, behaves and court process. We know about government and people vote yes or no, but it's interesting to everyone.
My point was, because you don't want to blindside fair share or a judge, I've been through those things, so.
Well, that is kind of my question, Karen, based on what you're saying, it sounds like the judge is not aware of, the changed circumstances in. That there also, is this new stormwater ordinance and New Jersey law that prohibits groundwater recharge, meaning that they have to really figure out where they're gonna put that water, right? So is the judge not aware of this?
So if you could like sit down, I'm happy to
And is
answer
it
that
a changed
question. So
circumstance?
Kelly and I have been in all the calls with Mitch and Councilman Lai, whom I thank very much, have started to participate in these calls as well. We have told the judge about PFAS in the neighborhood. We have shared concerns about the stormwater. And what was it, special master too? With the special, yes, the court adjudicator, the special master. So all of these conversations have been discussed, and I will also say that, you know, throughout the conversations, the subject of the landfill has come up in a general way with the court. Judge Miller knows Lambertville very well. He knows the history of Lambertville. He's very familiar with the city. He's familiar with our culture. He has, you know, he's got a lot of information, and we've not kept anything from him. We've told him every one of our concerns. So, Beth, and then we're gonna go to, I'm sorry, Dave, we'll go Dave, Beth, Dave, and then, Paul Stevens. And then the lady in the back who I can't quite see.
So I want to know if there is a specific timeline that we need to meet for third round and fourth round. I understand fourth rounds obligations. Unit is considered our third round, fulfilling our third round obligation. If we try to find alternate sites for third round, do we have a date that it has to be provided by?
Can I just add one thing too, before Kelly answers? And that's, we're already out of compliance, so we already need to do this, because we took the police station, we said we're not gonna do it here. And so we're already out of compliance, so the clock has been ticking for a while.
Yeah, I mean, is it fair to say?
I'm
that
not
we're-
sure I said it any better.
Yeah, I mean, it's fair to say that we're on the.
2025, but in our most recent settlement agreement, there were certain timelines in it that required us to take action on the police site.
Right.
We didn't do any of that. That puts us in, that makes us non-compliant. What you're talking about is switching sites,
Yeah,
okay?
yeah.
That,
Presenting new
that
sites.
is a whole new thing. That avenue hasn't even opened, you know, that discussion's never been had. Again,
Are we
you have to
going to have it
negotiate,
now?
you have to negotiate with Fair Share first before you do anything, with court approval. And again, what you need,
Offer one other thing too, you know, if you go to Fair Share, think about this, if we haven't been compliant and they look and they say, hey, you guys haven't been compliant, you never did the police station, do you think they're gonna work with us with pulling off the hill? You know, we've gotta show that we've got a plan that's gonna work, and so that really is what this comes down to. The starting point is a plan that they're gonna agree with, that they're gonna say, hey, we do wanna comply.
With Fair Share.
And, yeah, I wanna-
Because Fair Share is they just.
They're the other side that
They're
we're
the
negotiating.
litigant, they're the folks that sued us, that brought us into court on our affordable housing obligation. So they're the folks that filed the papers. So that is why when we talk about it, and we're not talking about other people or other sites, they're the litigants. So they're the one who sits in court. And they have to, and their opinion matters.
And, you know, just in terms of timing, so I've said that I've related the story before. I met with the judge and Fair Share and Kelly, I think it was 4 days after I was sworn in. And that was only 2 or 3 weeks after the police station site was, the redevelopment plan was tabled, I think, right? Was tabled. So, you know, the very first conversation, you know, question from the court, Fair Share was, what are you going to do about these 5 police station units? We were out of compliance, and it became, it's not the way a new guy wants to start a mayorship, but we got through the conversation, and it was shortly thereafter that KHOB approached us in, I think it was either March or late February. And you know, Fair Share and the judge were cautious, and that's why I had to go and have multiple meetings with them on a regular basis. They wanted to see, you know, if there was some possibility that the city could move forward and pick up 28 or 40 even, which is what KHOB originally, that was part of the original plan, 40 units. The court was very interested in the 40 units, and we stopped talking about the 5 units because, you know, this was moving forward. And it did move forward, and it did move forward in good faith all along. And so I think that's an important factor. And I don't know what's going to happen with the court, but I'd like to think that we've had a good, strong, open relationship with the judge and the court adjudicator. And I trust that Judge Miller knows the city well, and that we'll hear what we hear next time we hear something. I'm going to go to Dave Bird, and then it's Paul Stevens.
This is a simple, Dave Bird, 255 Brunswick Avenue. This is I hope, a simple question for the city attorney. All right, recognizing everybody has a right to sue everybody. All right, when the mayor sent the letter in on December 6th of 2024, did that completely end the relationship between KHOB and the city?
The contractual relationship we had by appointing them as conditional developer and the funding agreement, it ended the contractual relationship.
Done.
But as the mayor noted, they reached out, they wanted to talk further about why we sent the letter. The city obviously agreed, but there's no contractual relationship.
And that's water over the dam, you know, whether we're done, we're done. All right, and so we're done. The question on the 139, all right, are the permits been issued, all right, to a developer for the 139, or would, if that was brought back up by a developer, we go through the whole process again? And if we went through it again, all of the concerns that were raised during the 200 number, if you will, would have to be addressed again.
You mentioned permits. I missed that part. Can you just clarify?
Yeah,
There was no building permits.
Building.
No, we're not
Yeah,
even.
it's
close
ready to
that.
go.
Not even close to that point. If somebody approached the city with 139, I think the existing redevelopment plan, I have to pull it up. I'm sorry, I don't know this off the top of my head, but I think the plan requires that anybody the city entertains has some sort of site control. So that's a complicating issue, because right now there's an owner, then there's a contract purchaser. Anyone else who just came in out of the blue, they don't have any, unless something changes, they don't have site control as of right now. Those are the only two who we.
So the 139 is a relatively minor potential at this point, because we would be going.
It's an existing regulation. I wouldn't characterize that.
Yeah.
Contractual, that own the site or have contractual, you're gonna have to have a relationship with the owner to be able to move ahead one way or another. So it's kind of like, I can't
Nothing
fall out of
stops-
the sky.
Nothing stops either of those two entities, the current owner or the contract purchaser, from coming up with a plan for the 139 units. As we sit here today.
Unless we amend the plan.
I'm sorry, we've got an order here. Right before we take Paul's question, I also just want to highlight one other thing. You know, over the course of these 2.5 years, there was a lot of conversation about the village apartments and redevelopment there. There was a lot of conversation with the contract purchaser. There was a lot of conversation with the court. We were acting in good faith with the I don't think it was unreasonable for anyone on the dais to think that something wasn't gonna happen, right? And unfortunately, I shouldn't say unfortunately, it didn't happen, and there we are, but at the same time, we were working with KF Maine, and we were also working we never got to the status of conditional redeveloper with that entity, but we were having a lot of forthright conversations about the kind of property about the kind of development that the city wanted to see there. So there was a lot going on. And now, Paul, what's your question?
Reconfirm that we are in, we're not in what was the phrase we said? With the court.
We're not compliant.
Compliant right now, and it's important to understand this, it's because of the 5 units, not because of the ones up on Conant Hill. First thing we need to do is get in compliance, and there's gonna be a lot more acceptance of trying to potentially change the other units, okay? But we'd also have to come up with a plan for that to present a reasonable plan at that time, I would assume.
Yes,
That's
so,
fair.
and to that, I would say that, you know, when we started to, at some point during the early fall, and I believe that this was raised, the question was raised in a couple of different meetings about what are we doing elsewhere. That's when I began to explore the possibility that we could put Habitat for Humanity houses up at Holcomb Park, right? So it took me a couple of months to do some behind the scenes asking of the DEP and, you know, different entities and getting engineers up there, just to see whether it was viable, so that we can continue to have good faith with the court, right? That, and whether or not, and Kelly can respond to this, we haven't gone to the court. I mean, I don't remember, have we talked to the court about Habitat? I don't think we have. No. So we haven't even talked to the court about Habitat. It's possible. I mean, we're definitely going to talk to them about it, and I don't know what that.
We did discuss.
Possibly.
Yeah, they know that's an
It was
option.
very preliminary, but I want to, you know, I want to do everything that we can to stay in good stead with the court.
And I agree, and so in mine, and can tell me if I'm wrong, I see we have some short-term needs, some really short-term needs coming up. Some of them are part 3 and some are part 4. And then we have a more medium-term need completing out part 3, okay? Oh, and what happens if we don't do this? If we don't get in good, if we don't get back into what?
Compliance.
Compliance, thank you. Yeah, with the court, what then could happen to us? You should, I don't know, I'm not sure everybody understands what could happen. That's why I'm asking that again.
That's a good question.
So our immunity from builders remedy lawsuits would be stripped.
Which means what's a builder's remedy law?
So a developer, again, rough numbers, we have a hole in rough numbers. We have a hole in the 3rd round of 55 units. We just agreed to the 4th round number of 39. Someone can come in and say, tomorrow I can build X here at this density, and because you are out of compliance in round 3 and you don't have a plan in round 4, we lose the ability of to control our zoning and things that you would have addressed, things that you also would address in redevelopment plans, like density, for example. If builder's remedy comes in and says, I can do it, the court is inclined to look at someone that says, I can do it, and rather than look at the city and says, you have 15 years to try, what have you done? So that is the issue, is the risk of losing immunity.
Yes,
I just wanted to ask, as of 2018, you had a plan and agreement. Is that agreement still in place? With whom?
It's not.
It's
What we had in 2018 was the initial settlement agreement with Fair Share Housing Center, and the way that the Supreme agreement with this party, you go back to court and they do two things. In the first instance, they decide whether it's fair. Fair, is it good enough? Does it meet your obligation? Are the sites suitable, developable, etc.? Then you go back 180 days thereafter and show them the plan. The judge then says you're compliant, so you get 2 orders and then you have your immunity for that entire period of time. In 2018, there was an amendment that took us to the 2020 plan. Because some of the overlays at the time were not received favorable, we were not approving Clausen's, for example. That was a requirement to put an overlay. That was council at the time. When we made those swaps, the swap was essentially for the police site. That I went to court in 2023 with another amended plan. We took it to the judge, we took it to Fair Share Housing Center. They said, okay, swap, no Clausen's and a few others, YMAC and Fisher's. Sounds familiar, forgive me. The couple overlays we didn't do, so we swapped it for the police site. We went to the judge and we got through the fairness hearing. At the fairness hearing, the court found the developable, suitable, appropriate, and the obligation, of course, the numbers stayed the same. That's always important there. We have not gone back to get our final stamp that says you have immunity through July 1 of 25 because we are not compliant. That second piece is the compliance order. We can't go back and ask for it because we can't say, here's all the ordinances. City council adopted them, exhibit A, B, C. We did everything.
Thank
So
you.
that's, yeah, we're between them right now.
Just real quick, is the police department off the books
Yeah.
completely?
It's not on the books at all.
Okay, so
which
we
is why
can-
We're not compliant.
Right, we're not in
It's
compliance,
not-
but if we
it's not.
work on that first, I think. Like it's
Well,
easy, Jet.
But then we are, remember, we are then spending money to relocate the police department.
Right.
So
Okay.
there's a little on all this, but what's really interesting though is that just the great history that you talked about. So the court has worked with us a great deal and it's not the first time that we've swapped sites. I mean, we took an overlay off of this property and bought it and turned it into open space, which
And now we're
Fair Share
considering,
went along with, but again, there is a trust factor in that, perhaps a cynical. We have been working with the court in good faith. We have a good relationship with the court that I would hope would continue, especially understanding now we're not removing overlay to property to make a park. We have some significant concerns with the site that where we want to talk about. If you follow my logic.
no questions online?
No.
Yes, please.
And Michelle Glassberg, I have a question and I know what I don't know, and I understand, like developers have to be incentivized, right? In order to do 20% set aside or 20% affordable housing. Kind of relates to village apartments, and I know that you explained there was something brewing and it kind of walked away. But aren't there developers that just do affordable housing, like RPM Development Corp? I know just enough to make mistakes in what I'm saying, so like, wouldn't it be like more effective to try to work with a developer that specializes in affordable housing that's not worried about the set aside? So instead of developing 100, units and getting 20 affordable, you work with somebody like RPM that would just do all affordable.
So the first, I'm gonna say problem with that is that the property is owned privately. And the second concern or the second challenge with the village apartment site is that 85% of it is in the 100-year floodplain, which makes construction much more expensive to meet all the new requirements, for building in the floodplains, right? So already we have 2 strikes against us for that site, in terms of the economic incentive to build on it. So it's tough. There are, of course, developers. I'm sure that we could all talk about, companies that just do 100% development. But
I guess the key is there's 2 things about, look, there are some as of right units that could go on the 95 North Main Street Village Apartments. You get a lower set aside. I mean, the incentive for these developers is the 20% set aside. That's what pays for it. So when you have developers that come in that do a portion that's 100%, or like a Presbyterian homes, but work with the community, there's also a great deal of subsidies and tax credits and things that you have to you create a deal. And so if it was affordable or easy for municipalities to be able to build their whole obligation themselves, people will be doing it. And that's what part of the discussion even at the state level is that we have this new round 4, but we don't have like a bond issue that towns can go to help to try to pay for some of these things, to do some of these things. So they're great projects, you know. I've worked on some of them for vets and things like that, but they are smaller scale. And you know, they do take a lot of time, and we have that incentive in at Fisherman to work with Fisherman Mark on things up at you know, at the Clausen property. So but just to say that, like, you can't, you know, that for a lot of units, it's a lot of money.
But Councilwoman, I mean, is there any way the city can act as a matchmaker, for lack of a better word, on trying to like use connections or whatever, or reaching out or kind of getting
if we had a relationship potentially with the owner.
with the owner or with
I mean, then
representative?
if somebody wants to donate property, it takes a lot of the cost off a project right then and there. I mean, we would certainly be willing to be a matchmaker or facilitate something, but again,
I think if they're maybe for smaller projects, definitely, I think it's gonna be harder to do for a big project, and it can happen because you're gonna donate it, and we don't own any of the land, but that would be able to, you know, that we could use for affordable house. And the other thing too, with 100% affordable, sometimes, you know, that is not as preferred, because of the issue where it's just, everyone knows it's 100% affordable. Like, the nice thing about some affordable housing is it's sort of mixed in, so.
Yeah,
that's one of
we
the-
had a developer in our community right up the hill at Heritage Village, the Community Investment Strategies. That's their specialty, you know, is doing 100% affordable. But a lot of the times too, they do have the seniors unit. So then we get into only so many seats.
Right, because we need the
But
family.
there are a lot of people, and we would, you know, like, definitely, you know, that, you know, that's why initially the focus is on smaller ones. The funds are available, we own the land.
Please.
Yeah, so, we do have an ordinance about abandoned properties, and, that allows the city to, basically take over land that is a nuisance that's been abandoned, and, by eminent domain, which I don't know, has anybody considered that as a possibility for, you know, 100% affordable housing, or to at least fulfill our third and fourth.
I think is in the court record, $18 million that the city would have to bond and come up with. So that's, yes, you could do that, but again, that costs a lot of.
Yeah, as a policy, you know, it's a policy discussion this council has not had. I would not advocate taking by condemnation the village apartment site, for example, paying the market value for that, and then, you know, it's not cost, I mean, the city already
And
struggles.
compensating for value of the property, and
Thank
it's
you.
just more you lock it down and you say, you got it. You
Because
got
I-
it.
Yeah, I mean, I don't know, alternatively, if
It's been
this.
abandoned for like 5 years. What exactly is the property value?
Well, if this developer is not interested in doing any, I mean, if this property owner isn't interested in doing anything, I mean, like. Last I checked, they were not up to date on their taxes. You know, I know a lot of places, Merrick Wilson acquired a lot of his land because it went to auction, because he, you know, petitioned to have it, you know, the city basically. Potential possibility as well, to get somebody who is, right?
Maybe they could
Yeah,
talk
I
a little
mean,
bit,
I
I'm
could-
not a lawyer, so I don't wanna say, you
The
know.
mayor can attest this as
I-
well. We undertook some tax sale foreclosures recently and the law changed in the middle. So we filed a complaint and the law changed after a United States Supreme Court decision and then a state appellate court decision, and it put all these different requirements in it. Long story short, municipalities used to be able to, they foreclosed on a tax, on a property that was delinquent on its taxes. The municipality, all I had to do was file the final judgment of foreclosure and own the property. Now, the property has to go to, if you get that final judgment, it has to go to sheriff's sale because this Supreme Court decision requires the property owner getting equity out. So even, you know, if somebody owned the property for, they owed 10,000 in taxes, and the property is sold at sheriff's sale for $100,000, that person gets $90,000. They lose the house, but they get the $90,000 equity. That never used to be the case until the Supreme Court decision. So these properties, the city would have to bid on it at the sheriff's sale. And again, while it may not rise to the level of fair market value, it's still gonna be an expensive proposition on a buildable lot in Lambertville. I could imagine someone who can build a house on there that they could sell for $500,000, $600,000. They'd be willing to spend $200,000 to buy the land at the sheriff's sale and then build it. The properties that we're working on now are not buildable. They're just, you couldn't build anything on them. So they're not candidates for affordable housing. But if something came up in the future, we're still looking at spending probably close to 6 figures for a buildable lot in Lambertville. So it's a really, and that goes along with the eminent domain argument. It's not like the city can just take it for free. It's fair market value for a buildable lot in Lambertville. Just even a single family home is expensive, never mind something that you can put a ton of units on. So those are the considerations that, you know, we have to go through, and it gets expensive.
Are there any other questions?
So, hi. Just to clarify then, I know we are non-compliant, and to come into compliance, do we need to work down the police station? We need to work on 5 units, which in all likelihood would then foremost involve the police station.
So credits built in, so that's why I don't want to say 5, but the important thing is we need to come up with a small project that's gonna meet that obligation, get us back in compliance, and we are working on it.
And we're working on it. Okay, and in the meantime, can we not kind of have a double attack prong, 2 prongs? And with the Climate Hill, still kind of looming out there, it sounds like, as we were saying, it can just circle back.
Well,
Maybe not in the near future, but is there a way we can work on amending the redevelopment plan as it stands for Climate Hill, given all the information we have about it? I know that it's zoned that, and so the owner, private owner, right, and it's zoned for X number of, or a certain type of building. Can we then reduce the scope of what the redevelopment plan provides for, so that it's in line with what it's already zoned for at this point in time, as opposed to 139 plus whatever the amount is.
Yeah, that goes back to what we discussed previously, that wouldn't be something the council can do unilaterally, because the existing plan is part of the settlement agreement. We would have to go to court, we'd have to get Fair Share Housing Center's consent, and practically speaking, we probably couldn't go empty-handed. We would have to go with a new plan
With a new
to
plan
account
for
for
the
that,
other
in order for the
smaller
court and fair share to consider that.
One of the things you said too, I just want to make sure I understand, like, there are multiple things that we're trying to do to try to accomplish this, and you can't just say, hey, we're gonna do this and then wait and then pick up. I mean, we've got multiple things we're trying to do because we do have a time frame that we need to work with in June for the 4th round, and we're already out of compliance, so we do not have the luxury of time and just sitting back and saying, we're just going on this one track.
Well, also, I would explain that, now that we have these deadlines for the 4th round, the committee, and we've identified basically every place in town where something could be built. There's a little bit of an opportunity here to dovetail, and to work on the bigger number, not just, one or the other, right? I mean, in terms of the question of timing, it does give us the opportunity to look at the city completely.
Has a design and has the funding for 4 units, would the city be interested in that? It's on that, it's been passed around, all right? Somebody, an organization in this city owns the property, it is a plan already in place throughout the state of New Jersey and the United States. All right, development and a plan and the money and the funding, okay, for 4 units. That's 4 out of 5. That would be getting you in the right direction. If there's interest, somebody can talk to me.
Any final questions? I'll note that, the city. Now, but I just want you to keep that in mind, Jeff.
So real quick, two pieces. So because we moved, or the previous mayor moved the 5 units from Boston Farm to the police station that nobody wanted to sell, this kind of triggered this whole mess, that part of the mess. And now we may go back and put it back on Boston Farm. So it's sort of an interesting irony, but the point I wanted to kind of make is, so what's a real deadline for round 3? Because my concern is that we may bump up against it.
Again, I think when you say that we have in 2023 with Fair Share Housing Center, that is half approved. Again, we have a fairness determination, but we don't have a compliance order. When that it needs to be issued, that's unknown, right? The period is until July 1, 2025. But again, the police site had very specific deadlines in it, because to the ironic point you make, Fair Share wasn't also all too happy about the switch.
I understand.
So it was 6 months, 10 months thereafter, RFPs, naming redevelopers, etc. All of those deadlines have blown by.
And then, so what is it for the 28 units then? What's the deadline on that?
No, that, there is no non-compliant issue, so 28 units,
Right.
22 credits, 50 total,
Providing that we keep the current plan and we don't move it. I'm saying.
correct.
We only have what's the window we have to try to move it is my point.
Um, I'm thinking, because in the 4th round, the new law requires lookbacks and midpoint reviews to occur. Similarly, like we've done from the beginning of the Malwall Doctrine, and we just having done so many 5-year lookbacks because we haven't gotten a compliance order yet, but we update our annual monitoring. My point being is, in the new law, if there are sites that aren't being redeveloped that you designate redevelopment for, they require a review. So 5 years be clear, the law just came in.
No, I read the
Right.
law. It's-
Folks aren't, this isn't the issue that we're working, but I would say, I think because the third round is still in limbo, perhaps, it's
Kind of carries.
reasonable to assume that any judge that's looking at us in the fourth round may look back
That's
and
my-
see our prior
that's my-
mechanisms.
Well, that's why I raised the question. because
Yes.
My concern is that coming into the fourth round, someone could then challenge, well, you haven't done anything on the third round. We can now meet your third round, so give it to us. And that's my concern, how this
If
law is
you have
written.
if we have a viable fourth round that is flourishing and the mechanisms are being met, these 4 units, the market rates are affordable and accessory apartment, all of those things are working, and the look back did go into the third round. I think we're in a better position showing how compliant and a solid fourth round is versus reopening something in the third round
Yeah, I
that
was
hasn't.
concerned. Property owner, or developer might try to read it.
Yeah, you have that too. That doesn't.
That's my point,
That's
because
certainly.
under the fourth round, you can challenge plans, so.
Yes,
Michelle,
Yes.
last
She answered
question?
my question.
Okay. Any final questions? Any final comments?
Thank you for opening this
Thank
up to
you.
comment back and forth like this.
So I'm gonna ask for motion to close the public comment period. I still have a few remarks, before I ask for a motion to adjourn. All in favor, please say aye. Aye, thank you. I just want to talk a little bit about, what it is to be the mayor and what it is to communicate. And, this has been a difficult week for me. I will first start off by saying that I have never lied in this job. I don't need this job. I don't need to lie to anybody. And that is hurtful on a personal level, and I think it does the community a disservice in terms of how we communicate. I work very hard to communicate well and thoroughly and often to this community. And I may not, as I said earlier, always be eloquent, but I am earnest and I am honest. And the thing that is very hard for me as mayor is to see something like this and something like Mr. Ellis's letter, which refers to me as a liar. So I'm comfortable with who I am. I will not resign. I would not consider resigning ever. I do a good job and I work well with this council. And I respect every person in this room. I have a blast with the city employees. We have a good time. We work hard. I will never consider resigning. And if there's a move afoot, go ahead. I will fight you at every turn. I love public service too much to even consider it. I will say, however, though, that this kind of communication is deeply troubling to me. So when I was sworn in, when I decided to run for mayor, the one thing I thought I could do pretty well was calm this town down, right? It was full of vitriol and there was a lot of problems. There was a lot of conversation. People were not respectful. It was loud. And I thought I could do that. And I think I've done a pretty good job of it, put modesty aside. And I think it's time for us to talk a little bit about the community again. So it's not just how I communicate, it's what's responsible communication on behalf of residents. I will meet with anyone at any time, and I disagree. I think that sometimes if people would call me, I had an email this week from somebody who was irate, and I had a lady conversation with the lady. And I think I got more out of the conversation with the lady than I did out of spending 45 minutes writing an email trying to explain something to people that that should be that is born out of these kinds of things. I'm responsible for my communication. You're responsible for your communication and for how this community moves. A couple of other things. When we come to these meetings and we talk about community, or when we write to the mayor and say, the community does not want this, I would appreciate you telling me what community you're talking about, because this is a community of 4,000 souls, right? If you want to give me names, that's fine. But please speak for yourself. let your neighbors speak for themselves. Just because there's a general sense here among, you know, a certain number of people that the number of which I could not identify, that this is problematic. Fine, come do what you did tonight. I will always make time to have a conversation, and I will always tell you the truth. I'm gonna say that I really don't like these things. They're upsetting to me. I had one of the hardest summers I've ever had in my life this year, answering emails about this project. And a lot of them were emails that were the result of this kind of communication on behalf of members of this community. And I'm going to give a shout out here to Mr. Jeff Tittle, who on Facebook is free and easy with stating what he purports to be my ideas, my perspective, and my point of view. Pincushion for social media, and I'm going to start to voice my views, and I'm going to start to spar with you in these meetings if you continue to behave that. Impolite, and I think that it's not helpful. It's just not helpful. All of these things are not helpful. I will work 60 hours a week for the next 3 years. But I'll tell you what, public service is important, but not, you know, at some point, there's a tipping point with myself, with my self-care and and how I am. So I would like the community really, now, we're not having public comments done. I would like the community to really reflect on these values and how I think we should communicate with kindness, with clarity. We can get clarity by simply asking a question. So the questions were not asked. I was not given an opportunity to reflect or say, I think I may have misspoken, or my intent was this, or whatever. And unfortunately, because a couple of people have some idea that they're willing to perpetrate, I have to answer emails that I shouldn't have to answer, and charges that are specifically lobbed at my integrity. So I don't want it, and I'm not going to have it anymore. You want to have a conversation in the public forum. Look to the public record. Do not say what you think is going to happen or what you think I said. Quote me. Come and see me. I'm done with this. It's too hard for me as a person to have this kind of communication happen in our community. It is. And as Judy Gleason can attest, I lost my cool this week. I'm not a person who loses his cool very often. But I want more respect because I think I've earned it. And I think that it does it. I think that as a community, as 4,000 people, we should be kind to each other and respectful. And so on that note, I'm going to ask for a motion to adjourn.
No, we're not going to close.
Well, yeah, I'm sorry, we have to go to closed session. So I have a motion to go into closed session, please, to discuss. Can you read the thing?
Do you have a cannabis?
No, we're not, there's no, I just mentioned that at the beginning of the meeting, we have a full agenda.
We're going into. Okay, going into discuss matters related to attorney-client privilege pursuant to NJSA 10:4 12 7.